Hello, everyone, and thank you for checking out this video. As in our past videos and live webinars, we work to bring you the best advice from experts on a wide range of topics. Our goal is to leverage our independence as a team and our ability to separate advice from custody to best serve you and your family. We encourage everyone to share our posts and event invites with friends and family if you could believe it could be helpful. The biggest compliment we can get is an introduction. Today, we welcome David Staggs, an excellent private attorney who actively works with clients building estates, trusts, and wills. David continues to be an excellent resource to us, and I want to thank you again, David, for joining us today. I think the topic today
Absolutely.
can be pretty applicable to just about anyone, ensuring that no matter what point you are in life, taking the steps to secure your estate is crucial. David and Jesse will also be taking the time to discuss a few newer developments in the space. It'll be great to know when working with an estate attorney. Last thing for me before I turn it over, I'd encourage everyone watching to check out our other pages on Instagram and Facebook at Veritas Private Wealth. Thank you both for taking the time, and the floor is yours.
Excellent. Cole, thank you so much as always for setting these up. David, before I jump in with my first question, I always like to, thank you for all the work that you've done for clients. David has been a partner of ours for some time, and he has done some terrific estate planning work for clients, and looking forward to hearing some of your thoughts today. I think we'll just keep it to 10, 15 minutes conversation, and people know how to follow up with either one of us if needed. And so we'll just jump right in. So I think we want to start with, what something that young couples or individuals can do to start the process for getting their estate in order.
Yeah. Yeah. And it's a common question. And I say the same thing every time. When you're starting something, start with the basics, right? Start at the ground level and put things in place, put a simple structure in place, and then see if you need something more, see if you need something more complicated. So my advice is that anyone over the age of 18 that owns any piece of property, whether that's real estate or a car or a bank account, should have at least a will, a healthcare proxy, a power of attorney, and probably here in New York, a living will as well. So, from my perspective, to do that, you think about, what do I own? What liabilities do I have? And then think also about beneficiary designations, right? Do I have beneficiary designations on things like life insurance or retirement accounts, things like that, that can dovetail with or conflict with your estate plan if you have forgotten about them? So when you think about those things, and then you think about your family, do I have children? Am I married? Do I have grandchildren? Do any of the people that I want to benefit have any sort of special circumstances in their life? Does someone have supplemental needs where they might need additional assistance? That sort of information, once you're armed with that, it's a great place to get your estate plan started. And then you start with those initial documents, get your will, healthcare proxy, power of attorney, and living will in place. And then you can look up and see if you need more.
That's great. I think that would be a great segue into speaking a little bit about what's going on right now from the landscape of potential unified credit provision changes and inheritance changes. So maybe you can talk a little bit about that, some of the planning that you're doing, or what people should be looking at or thinking about. Do they need to be doing any planning, right? I'm sure everyone's hearing that, some of the prior tax code will be, perhaps expiring and so forth.
Sure, sure. So for the uninitiated, or for those who don't know, currently the federal government says that you can leave a little over $13.5 million. An individual can leave a little over $13.5 million to anyone in the world without having to pay any estate tax. If you're a married couple, that means that you're just over $27 million, right? That's a big number. Now, some states have estate tax as well. Here, Connecticut, ours is just under 7 million. Excuse me, here in New York, ours is just under 7 million. I'm also licensed in Connecticut. Theirs is the same as the federal one. So for most people, for most Americans, estate tax is just not a concern anymore. Now, when this increase in the exemption, this is the highest that the estate tax exemption has been. When this increase was put into place, it was set in with a sunset provision, which means that as of under current law, as of January the 1st, 2026, that $13.61 million estate tax exemption will automatically be reduced in half. So because it grows with inflation, a reasonable estimate would be to say that as of 2026, the estate tax exemption will be about $7 million. It will be half of what it was December the 31st of 2025. So for those people who do have estate tax issues, if you have the ability to transfer anything above $7 million and still live your life comfortably, doing anything and everything that you've wanted, and it makes no change to your life circumstances, then people who are in that position right now are structuring trusts to make taxable completed gifts. Because what happens is you go to bed on December the 31st of 2025, you have this $13.5 million exemption. You wake up the next day with $7 million of exemption gone. And at a 40% tax rate, that means you're now paying 40% of $7 million in tax that you wouldn't have had to have paid if you had made the gift. But the code is structured in such a way that to use this sort of temporary short-term increased exemption, you have to use it before the end of 2025. So for people who are in that position, making large taxable gifts before the end of 2025, that has been our priority and our focus since at least 2023, 2022, but probably going back even a little bit more as we understood that this exemption will go away and it will disappear and that you've got to give a lot to be able to use it. So that's a big change. It's a big change, and people who are in that situation are preparing for it. But even when it gets cut in half, Jesse, a lot of people don't have to worry if a married couple can distribute $14 million to their beneficiaries without tax. They're not too terribly worried about estate tax either. And so from that perspective, we've shifted to a certain degree for a lot of clients where we're focusing our estate planning.
And so thank you very much for that. It's a pretty comprehensive overview there. So I guess my follow on would be then, okay, so let's say, sounds like if our estate's over that amount, right? The 14 or so per person, we have some planning that should be thought through.
Right.
If we're under it, what are the things that we should be thinking about in that group in terms of, okay, let's just say it goes back down. Is there anything specific or top of mind for you that we should be thinking about?
Yes. So, and part of the reduction or part of these increased exemptions that I'm really enjoying is that some of our clients who are on the border under the old tax rules, under the lower exemption amounts, that's what the focus is. And when you're not worried about estate tax, people have the ability to think about things in their estate plan that really matter to them. From a tax perspective, we're thinking about income tax, right? So when a person dies under the estate and income tax rules, if an asset is included in their estate, they get an income tax basis adjustment. So if a parent bought a stock for $100,000 and at the time they die, it's worth $500,000, when their kids inherit it, their income tax basis is $500,000. So their kids pay no income tax, right? So we're focusing on how do we leverage the basis step up and how do we counterbalance that with people who are close to being taxable? Because most people aren't close to being taxable, there's a lot of income tax basis planning that we can do. We take a look at people's existing irrevocable trusts and see if they're necessary. If they're not close to being taxable, maybe there's a way we can cause those assets to be included in their estates and get that income tax basis step up for the next generation. So that's been the tax focus, but mainly people are focused on things that they really care about, right? Questions like, well, if I die and I leave my assets to my children and they get divorced, do their spouses get to run away with half of what I left my children and spend that money with their new spouse? And the answer is, well, we don't have to do it that way, right? We can leave assets in trust for people's kids, for people's beneficiaries, so that they have some asset protection against creditors. And to me, my clients find the most important creditor that their children will face is a potential divorcing spouse.
That's great.
So we get to focus there instead of focusing on tax all the time. It's a real benefit to the clients.
Okay. Okay, that's great. Certainly making sure that we have revocable trusts set up, looking at if there are any assets that we want to bring back into the estate to have an increase in cost basis. We do plan a lot around that with clients. Most clients don't really want to sell assets during their lifetime, right? They're living off of income, which is the great way to do it, and then they get this nice benefit of the step up. So there is a lot of planning in terms of structuring of accounts that goes into that. So that's a great thought.
Yeah.
Okay, so I had one last question, just from an overview process. So, we've had a lot of people have to go through probating um, estates. So maybe you could just walk through from a high level, what do we need to be thinking about when we're probating an estate? What are the first things you talk to clients through?
So prior to COVID, probating an estate was somewhat difficult. During COVID, it was mostly impossible. And now it's gotten a little bit better in some counties, but in other counties, it's still a very difficult, it's a very lengthy process. So whether if a person owns assets in their individual name, right? Not every asset is a probate asset, right? Life insurance that has a beneficiary designation, jointly owned property that passes by operation of law or right of survivorship, those aren't probate assets. But if you own assets in your own name that aren't held jointly with someone and that don't pass by operation of law, you have to go through the probate process, whether you have a will or not. And that's a confusing thing for a lot of people. A lot of people say, well, I have a will, I'm doing that so I don't have to go through the probate process. And it's no, by definition, probate is the proving of a will. Every will must go through the probate process. And it starts with filing a probate petition with the surrogates court here in New York or with local probate courts if you're in other jurisdictions. And here in New York, we have to send out notice to the beneficiaries under the will. You have to send out notice to who would inherit under the state law if the will was held to be invalid, and then sometimes creditors as well. And that starts the probate process. If everyone is in agreement with the will and okay with it being probated, then it can move forward relatively quickly. But if anyone is a minor or if anyone objects, then that process can take quite a while. Here in New York, depending on your county, even if there are no issues with the probate petition, it can still take 6 months to have an executor appointed for an estate. In the meantime, no one can use those assets to pay bills. No one can use those assets to pay creditors, funeral expenses, mortgage payments. It can really be a burden for the surviving family members, especially in situations where you're relying on those assets. That's what you use, that's what you live off of. And now all of a sudden you're locked out. And we see situations where people do things like spend retirement account assets to pay for these things because that's the only asset that they have direct access to because it was with a beneficiary designation. So this is where things like life insurance, or more importantly, structuring your estate plan so that you can either completely avoid probate or partially avoid probate becomes very helpful.
It sounds like that's great. It sounds like the best way to avoid probate is with some of these living trusts.
Yes, yes. So revocable trusts have become they were not too terribly popular here in New York for many years. They've become more and more popular over the last 20 to 30 years, I would say. They're very, very popular now. They work very similarly to a will in that they don't really take effect for your beneficiaries until after you die. You can change them at any time that you want during your life, but you transfer your assets to them now. So if you have a bank account, you close it down and you open a new bank account in the name of the trust. And now, when you pass away, it's a non-probate asset. And so that asset does not have to go through the probate process. And I've seen people take it all the way to the extreme and transfer every asset that they own to their revocable trust so that there's literally zero probate. And other people want to do something like have a revocable trust, but they only want to transfer a portion of their assets. And their main concern is I want my beneficiaries to be able to have direct access immediately and not have to wait maybe 6 months before an executor gets appointed.
So that revocable trust gives you some protection from ex-spouses and creditors, and gives you a little bit easier probate process, gives you control of your assets while you're alive. So it's a pretty, uh, I think, well-received tool for our clients. Um, All right, I'm going to throw one curveball at you just in the last minute or so. I'm wondering if we can just talk a minute about a slat, and that's gotten a lot of press lately with this, for these clients that are trying to take advantage of this higher exclusion. So from a high level, can you just walk me through, um, I need to be thinking about a slat if I have over $24 million. Why do I need to be thinking about it? What's the high level description of it?
Right. So with these increased exemptions, people are thinking, how can I use this exemption? I'm going to lose it in 2026. How can I use my exemption? Well, the answer is if you have unlimited resources, you can make gifts to your children or other beneficiaries that you can't benefit from directly or indirectly, right? Because you don't have to worry about that changing your lifestyle. For people who are closer, let's say you have $30 million as a married couple, you can give away $27 million, but then you're left with three. Is that really going to be enough to support the lifestyle that you had when you had $30 million? And in steps the spousal lifetime access trust. And for years, estate planners, we didn't think that this was possible, right? So the tax code says that if you give an asset away, but you maintain the ability to use it for your own benefit, we're still going to tax you on it when you die. And so people were nervous about transferring assets to a trust of which their spouse was a beneficiary, right? If you transfer a residence to a trust and your spouse is a beneficiary, if you spend the night in the house, is that you using the property, and is that going to cause it to be included in your estate? Well, we now have case law that says, no, we don't think that that's going to be a problem. And so a spousal lifetime access trust, or a SLAT, is a trust where one spouse creates it, one spouse funds it, and the other spouse is a beneficiary. So during the lifetime of the beneficiary spouse, you have indirect access to those funds. You don't have to give them so far out of your domain that you can't possibly benefit from them, right? Not the surviving spouse. In this case, the spouse is still, both spouses are still alive, but the non-grantor spouse, the beneficiary spouse, they can access that property and they can use it if need be. Now, mind you, the goal of a SLAT is never to touch it, right? Because if you transfer $13 million into a SLAT and at the time of your death, it's valued at $100 million, all of that escapes taxation. So if you're going to use assets, you want to use assets that are outside of the SLAT, because those assets would be taxed at your death. I always say, if you have to spend money, spend the money that's going to be taxed. Otherwise, don't spend the tax-free money.
That's great. So I really appreciate the partnership, David, and the time. And Cole, thank you so much for setting these calls up. And I hope everyone finds some value out of it. And certainly reach out to David or I if you have any questions. And we'll look forward to hearing from you.